Okay, this is file 24-22008, People versus Chad Weston Till. We are here today for sentencing in this case, and we are proceeding today by video, in person. First, Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Till this morning, Your Honor.
And sir, you're Chad Weston Till.
Yes, Your Honor.
Mr. Till, have you had an opportunity to read and review your pre-sentence report?
Yes, I did, Your Honor.
Did you have an opportunity to discuss that report with Ms. Underwood?
Yes, I did, Your Honor.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, Your Honor.
Do you wish to explain or challenge the accuracy or relevancy of any of the information that's in your pre-sentence report?
We do not, Your Honor.
No, Your Honor.
Ms. Underwood, does the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
It does not.
The probation officer has calculated the minimum sentencing guidelines to be from 5 to 17 months. Do you agree with that computation of guidelines?
We would agree with that calculation, Your Honor.
All right. Before the court passes sentence, then, Ms. Underwood, is there anything you'd like to say on behalf of Mr. Till?
Yes, thank you, Your Honor. Mr. Till, Your Honor, is here on a prisoner possessing weapon case. But I think it's significant to note, first of all, Your Honor, that the only person Mr. Till in danger with that weapon is himself. This is a very sad case where Mr. Till has serious issues with taking out his mental illness on himself and trying to cut himself. I don't know how they're going to work with Mr. Till to get him to stop that, Your Honor. I really hope they do. I hope Mr. Till takes whatever treatment is available to him, because he really needs to do that. I think the cops in this matter, and Mr. Till, and I thank the court for that, is appropriate. We would ask the court to sentence Mr. Till pursuant to that cops to the low end of the guidelines to a sentence of 5 to 30 months, Your Honor.
Okay, Mr. Till, is there anything you'd like to say on your own behalf before the court passes sentence?
Yes, Your Honor. Just like Rhonda Underwood has said just a minute ago, I do have an issue with my mental illness factor. I have over 147,000 scars on my body, arms included, and my legs, inner thighs, upper torso, and also both arms. These cuts are endangerment to myself because I did them to myself with altercations of weaponry, altercations of pieces of scrap metal that I have found, razors, pieces of plastic, hardened plastic, anything that I could find. There have been points at which that I have recently get cut, but those scars are hidden and well concealed because I'm afraid of what they'll do to me. They don't give me the necessary help that I need at that facility. Or they didn't even give me the necessary help at Gus Anderson. WCC was the best help for me, but they refused to write me out to that facility. There they had programming that I could do to keep myself busy and preoccupied. Other facilities wouldn't be able to do that. That's all, Your Honor.
Thank you, Mr. Till. In determining the appropriate sentence in your case, the court has considered the seriousness of your offense, your history, the principle of proportionality, the statutory penalty, the cost of confinement, report and recommendation of the probation department, as well as what's been said on the record here today. The criteria and reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to its commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Till is 34 years old, has 3 prior felony convictions and 1 prior misdemeanor. In this case, has been convicted of being prisoner in possession of a weapon, or attempted prisoner in possession of a weapon. I do think that under the circumstances that the sentencing agreement is appropriate in this case. Obviously, Mr. Till, the weapon, whatever it is you had that you used to cut yourself, is not something that anyone wants to see happen, and it presents a danger to you, but it also presents a danger to everyone in the facility, because it could be taken from you and used in a way that you don't intend. So that's another thing that we're trying to prevent from happening here. But I do think that it is appropriate to follow the terms of the sentencing agreement, so I will do that. The low end of the guidelines was 5 months in this case, so it will be the sentence of the court that Mr. Till served. Period of 5 months to 2 years and 6 months with the Michigan Department of Corrections.
It's 30, Your Honor. It's 2.5 years, I believe.
Yeah, I said 2 years and 6 months.
Oh, it's 2 years?
2 years and 6 months.
Okay, yeah.
So 5 months to 2 years and 6 months with the Michigan Department of Corrections. That sentence is required to be consecutive to any sentence that you're serving now, under the circumstances that it was committed. The statute requires that, so it doesn't. You must also pay the statutorily required $130 crime victims' rights and $68 state cost. You have the ability, Mr. Till, to request an appeal of your sentence. The bailiff will hand to you 3 copies of a notice of right to appellate review and a request for appointment of attorney form. You need to sign 1 copy of that under the receipt of notice heading and return that to the bailiff. That just indicates you got your copies of that form. And if you want to appeal your sentence, I just need the top copy back and he gets the other 2.
I'd rather not appeal it.
Okay, that's fine. I'm required to tell you what your rights are in terms of the appeal. So if you want to appeal your sentence, you need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Or if you wanted, we would give you a chance to fill that out today before you left. Okay. All right. Thank you. Then I think we're all set.
Thank you. I'm gonna go get on the Zoom
Okay.
for the pickup and Mr. Lyles.
Okay. All right, Mr. Lyles, Ms. Underwood is going to log in on her device, and as soon as she does, I will have you speak to her.
Yes, sir.
Is the 8 o'clock still on?
No, that is.
So it's consecutive, right?
Correct.
I like to mix up consecutive in my notes. I have a logical reason why, but I. Are they in person?
They should be in person.
How long does it take them to fix this? Or did it take down the hands?
Hers is not fixed yet. Her part just came in. State, I think.
Are they on some boat from China?
I don't know where that-
Because this company used to be, I don't know if it still is in Canada.
Oh.
Yeah. I don't know if it's still is owned by them or it's been a while ago. Kelly said they'd had the same problem in probate. And,
Apparently they've had it in both district courts and probate courts.
oh, really?
It's- it's- goodness,
Well, I think the last time Pat and I talked and we had checked, Lonaway's one of the only courts, there's maybe 2 courts in the whole state still using this, and we're one of them,
Oh, yeah.
somewhere along that line, but
Seriously.
yeah, roles been around a long time. The reason everybody picked the system was because you could incorporate the 400, all of the docket. You
Yeah.
could draw it in and automatically incorporate it. You can't. Now that they've switched and you don't have anybody backing, you can't do it anymore. So you have to manually enter everything on the state.
Okay, this is file 22-20789-FH and 23-2143-FH, People versus Jacobe Wayne Lyles. We are here today for sentencing in this case, in these cases, and we are proceeding today by video conference, probation violation sentencing. Ms. Underwood, do you want to place your appearance on the record?
Ron Underwood for Mr. Lyles this morning, Your Honor.
And sir, you're Jacobe Wayne Lyles.
Yes, sir.
Mr. Lyles, this is a sentencing in a felony case. As a result of that, you have a right to be present in person in the courtroom for the sentencing hearing. I would only proceed by video conference today if you're willing to waive that right and continue by Zoom as we're doing now. Are you willing to do that?
Yes, sir.
Have you had an opportunity to read and review your pre-sentence report?
Yes, sir. I'm actually not charged with a CCW. I'm charged with use of non.
Okay, well, I'll get there in a minute. I've got to ask you
All right,
another
yes,
question.
sir.
Have you had an opportunity to discuss the report with Ms. Underwood?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice she's given you?
Yes, sir.
All right, and so next question is, do you want to explain or challenge the accuracy or relevancy of any of the information in the pre-sentence report? And you had started to say something about what you were charged with.
Yes, sir.
Okay, so go ahead with that.
Yes, I did have a pocket knife when I was stopped. I've never had a weapon charge in my life. I've walked around with a pocket knife in my pocket my whole life and never ever used a knife or any type of weapon of sort on anything like that. The only reason I actually had the knife, I was working on an 18-wheeler in Monroe, TA. I had to change out the brake chamber. One of the fittings on the air hose broke off in the air brake chamber, so I had to go in Monroe, TA, and buy the knife so I could replace the fitting on the hose and replace the brake chamber. That is the only reason I actually had a knife to begin with, and I'm just, yeah. But like
Mr. Lyles.
yes, ma'am. Thank you.
Okay, so I thought you started to say that you were not charged with carrying a concealed weapon. So were you charged with that or were you not charged with that?
I was charged with it, but they dropped that, and then they also lowered my controlled substance charge to use a non-narcotic, because those were only Tylenol 3s that my aunt left in my bag, because I let her use my backpack to go to my little cousin's volleyball tournament, and she left them in my bag, and that was my backpack I used for work.
So I guess it's correct as to the charges, Your Honor. Mr. Lyles would just like you to know what the resolution was.
Okay, yeah, I understand that the charges were reduced as a result of the plea agreement.
Oh, okay. Yeah, I'm sorry for the confusion.
Thank you.
Is there anything else in the pre-sentence report that you challenge the accuracy or relevancy of?
No, sir.
Before the court passes sentence, Ms. Underwood, do you want to say anything on behalf of Mr. Lyles?
Absolutely, Your Honor. Mr. Lyles, Your Honor, as he just said, understands that what he did was wrong. He further understands that he should have, his first call should have been into his probation officer. Mr. Lyles is in the process, Your Honor, of taking care of what he needs to do in Monroe County. I believe that's going to include a intensive probation.
No, there's
no probation.
no
Jacobe?
probation. I'm
Okay.
free and clear.
So he will be done. Your Honor, while Mr. Lyles has been incarcerated, he has lost his grandfather. I know his dad has serious health issues. And Mr. Lyles also
has not seen his son, Your Honor. I understand the recommendation is for the 11 months, Your Honor. We would hope that the court, in its mercy, understanding that Mr. Lyles has been incarcerated in Monroe on a 90-day sentence, would consider something lower, Your Honor, like 6 months. If the court would consider that. I think Mr. Lyles understands, Your Honor, that he needs to get out, get his life together, find stable employment, and a place where he can bring his son for visitation, Your Honor. That's all he wants to do. Thank you, Your Honor.
All right, Mr. Lyles, is there anything else that you want to say on your own behalf before the court passes sentence?
No, sir.
What date were you arrested on the Monroe County charge?
I was arrested January 21st.
Okay, so this is a case where Mr. Lyles has had 2 previous violation of probations in the past. One was for a technical violation, and I served 3 days jail at that time. One was for a non-technical violation, served another 3 days jail at that time. And in this case has another non-technical violation for violating criminal law. It's also apparent from the pre-sentence investigation report that Mr. Lyles was not truthful with his probation officer regarding his contact with the police.
I was going to say that I actually did contact Mr. Jones. I don't think he recalls me contacting him because I let him know the day I reported that I came in contact. So I don't know why it's being said that I didn't let him know anything of it. Your Honor.
Well, the report indicates that you reported and you told him no in response to the question of whether you had been in contact with the police. And another concern for me is that one of the conditions with probation was that Mr. Lyles, you were required to participate in some treatment, some anger management programs, and haven't accomplished that.
I have done an anger management class since I've been here.
You had a long time to do that before you got incarcerated in Monroe County.
Yes, sir.
And you chose not to.
I mean,
And so when I look, you've had your opportunity to speak now, Mr. Lyles, and now I'm giving you the reasons for the sentence. Unfortunately, you just haven't complied with the terms of your probation in a way that would persuade me that it's the right thing to do to continue to defer the original 12-month sentence that I deferred when we started your probation. In many cases where there's a deferred sentence, someone receives the deferred sentence the first time that they violate, and now we're on the third violation in your case. So I'm at a point where if I don't follow through, my words aren't credible. And if I continue to allow the non-compliance with with probation that has occurred up until this point, then it all kind of becomes meaningless. So it is going to be the sense of the court. I will give you, I will take some time away for the time that you spent in Monroe County since January. So with respect to file 22-20789-FH, it will be the sentence of the court that Mr. Lyles served 10 months jail with credit for 25 days served. With respect to file 23-21433-FH, it's the sentence of the court that Mr. Lyles served 9 months jail with credit for 12 days served. Probation will be revoked on both dockets. You do have the right to request an appeal of your sentence, Mr. Lyles, when we will send to you 3 copies of the notice of right to appellate review and request for appointment of attorney form for each file. When you get those, you need to sign one under the receipt of notice heading and return that to us. That just indicates you received your copies of the forms. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that?
Yes, sir.
All right. That is all then for today. You can let the officer with you know that you're done with work.
So how long am I gonna have to do jail?
So you have 10 months with credit for 25 days.
There's no way we could go back to the day I got incarcerated?
The sentence was, I reduced the sentence. I was going to give you 12 months. I reduced it by 2 months for the amount of time that you've been incarcerated in Monroe.
All right, so 10 months.
Correct.
Judge, those two will run concurrent, correctly? Correct.
Thank you, Mr. Jones. Yes, those are concurrent to each other and concurrent to any other sentence that Mr. Lyles is serving.
So I'll be free and clear when I'm done here, and y'all pick me up when I get released from here.
That's correct. I would presume that they'll come and get you and bring you to Lenawee County when you're done with your time in Monroe County. And when you're done with your time in Lenawee County, you will be done completely with both cases.
Thank you, Your Honor.
Great, thank you.
I'm good to go.
Yep.
Thank you.
Okay, could you call the jail for Mr. Marquil?
Judge, that pickup's not a criminal pickup, correct?
Correct, that's a friend of the court.
Okay, I'm gonna go next door then. Thank you.
Thank you.
Good morning, this is Mary, Judge Olsavers. Can you get Marquil Anthony Love for judge, please? Thank you.
Hey, Francis, do we have the warrant for Mr. Love yet?
Yes, bringing it right now.
Okay, thank you. Thank you.
Sorry.
Okay, I have jail room 4 logged in, and the camera is off and the video, or I'm sorry, the microphone. There we go. All right, sir, you are Mr. Love.
Yes.
Okay, this is file 23-50631-DS. Jessica Jeanette Carlson versus Marquil Anthony Love. We are here today for an arraignment on a bench warrant for a friend of the court show cause, failure to appear at friend of the court show cause. Sir, you are Marquil Anthony Love.
Correct.
Have you received a copy of the bench warrant, Mr. Love?
Yes.
The bench warrant alleges that you failed to appear for a friend of the court show cause hearing. The underlying show cause hearing dealt with the fact that you have a monthly child support charge of $453 and an arrearage that is currently $7,343.44. Do you understand that?
I do, but I just don't understand why it wasn't coming out of my paycheck when I was working at AK.
Okay, all right, I'll give you a chance to explain in a minute, but I've got to ask you some questions to make sure that you understand what your rights are before we get into that, okay?
Okay.
Do you understand that it's a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yes.
Do you understand that it's a crime to fail to appear here in court when you've been ordered to appear?
Yes.
Do you understand that if you were to plead guilty to either of those offenses, that you could be sentenced to jail for up to 30 days?
Yes, I understand.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
Yes.
You are entitled to have an attorney represent you here today and at any other proceedings that we have regarding this matter. And if you can't afford an attorney, you can tell me that right now, and I'll appoint one for you from the public defender's office. Do you understand that?
Yes.
Would you like to be represented by an attorney?
Yes, because I can't afford one.
Okay, I will place you in a breakout session with Ms. Underwood from the public defender's office right now. Doing a bench warrant arraignment right now. Okay, Ms. Underwood, do you know how Mr. Love would like to proceed?
Yes, Your Honor, thank you.
And how's that?
Rhonda Underwood for Mr. Love this morning, Your Honor. I would ask the court to enter a not guilty plea on Mr. Love's behalf. Your Honor, Mr. Love ran into a real transportation issue. He has recently got transportation and is going to be able, he talked to his employer, his former employer. What's the name of the landscaping firm?
AK Lawn Care in Milan.
AK Lawn Care in Milan. He should be able to get that back, Your Honor. We would ask the court, Mr. Love believes he can come up with a $200 payment by Monday, Your Honor. We would ask the court to set this for a short adjournment, giving Mr. Love a PR bond to make a $200 payment on Monday, and perhaps set this for a week or two down the road. And Mr. Love will have steady employment and a new income withholding order or income withholding back in place. I believe Mr. Love still lives on the address the court has on Power Highway.
His address is actually confidential, so I don't know. I can't confirm. I don't have it in front of me to say yes or no to that.
I'm still there. I've been there.
No, I mean, I
Okay,
don't,
Mr.
I
Love.
can't tell you what, I can't tell you what the court has for your address.
Oh, I see.
Yes, my concern with this case is that when the bench warrant was issued on May 1st of 2024, the arrearage was $1,865. The arrearage today is $7,343. And just doing some quick math, $453, that would mean that Mr. Love has made almost no payment on this case in the time that he has had this bench warrant outstanding. Which is coming up on 11 months. There isn't a lot here to inspire confidence in me that Mr. Love is going to appear when he's told to appear and do the things that he said he is going to do, because there does not appear to have been any track record of doing that in the past.
I had court downstairs for no insurance. I've never missed any court date that I've known about. So when I had that court date and that got all settled downstairs, he asked me if I had any other court dates, and I didn't know anything about these court dates. That's the only reason why I never showed up. And every time that I've had child support taken out of my check, it's automatically came out. So I was told that I was on child support, so I assumed that it was automatically going to come out of my check like normal. I never checked my check stubs because it was online, so I've never worried about that. That's the reason why I wasn't making any payments. I try not to talk to my ex anymore because every time I talk, it's just a continuous argument. And I'm not trying to be in that negative environment anymore. So I can guarantee you that I'm going to show up. I'm not trying to sit here and neglect on anything that I need to take care of. That's why when I got pulled over last night, I was happy to tell him, like, hey, I'm absolutely fine with this. I'd rather get it taken care of than to sit there and not have it taken care of and have to worry about something over my head that I didn't even know anything about.
All right, you're gonna get one chance, Mr. Love. I'm gonna give you a PR bond with the condition that you pay $200 by Wednesday, March 26th.
Wednesday, March 26th.
That's next
You-
Wednesday, Mr. Love.
Okay.
And then we're gonna set this for a hearing on Monday, March 31st at 8 a.m.
So a hearing for March 31st at 8 a.m. Payment of $200 by Wednesday.
Yep,
Correct. If you're not here on Monday, March 31st at 8 a.m., I'm going to issue another bench warrant. And at that point, I'm not going to have any discussions about bond.
Okay. Understood.
All right, so you are all set for today. You can go ahead and let the officer with you know that you're done with court.
Okay.
thank you, Your Honor.
Thank you, Ms. Underwood.
Have a good day, Your Honor.
Thank you, Mr. Vasquez.